All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
Good morning. Welcome to the DC Court of Appeals in our virtual form. We have two cases on the calendar this morning. The first is Brown-ALFORD versus the United States, 20 CF 224. Ms. Biederman, when you're ready, if you could state your name for the record and let us know how much time you would like for rebuttal.
Certainly. Good morning, Judges Easterly, Deal, and Kravitz. I'm Donna Biederman, and I am on behalf of the appellant TAHJI Brown-ALFORD. I would like to reserve 2 minutes for rebuttal. We have two questions before the court this morning. The first one is when Mr. Brown-ALFORD was seized, and was there reasonable suspicion for the stop and probable cause for the seizure? And that's the second one, whether there was reasonable suspicion for the stop and probable cause for the seizure. The government has made two arguments in their briefs. The first one is that the smell of marijuana can be used in conjunction with other non-enumerated factors in the statute to reach reasonable suspicion. We don't need to reach that question because there aren't any such things here. The second argument was that seizure did not occur until Mr. Brown-ALFORD was captured. And since then, the Supreme Court has unequivocally said that's an incorrect reading of the law. The government did file a 28K letter with that case from March. Mr. Brown-ALFORD was stopped and seized here in the absence of reasonable suspicion and probable cause. And so he could not have been stopped, and he certainly could not have been ordered out of the vehicle and seized.
Can you just tell me, are you accepting the trial court's view that the stop occurred when there was a knock on the door directing Mr. Brown-ALFORD to get out of the car? Or do you pinpoint some other spot in time where you think a seizure occurred? Well,
we believe that's the latest that it could have occurred is when he knocked on the door and ordered them out of the car. The time from when the police surrounded the car to that point is a matter of seconds. But that is definitely the latest that the seizure could have occurred is when he knocked on the window and.
Right, I guess I'm not asking when the latest is. I'm asking what your position is on when he was stopped.
Yeah, I would accept that as when he was stopped, is when they knocked on the door, knocked on the windows, and ordered them out of the car.
At which point, correct me if I'm wrong, what we have, the factors that would contribute to reasonable articulable suspicion include the smoke in the car, the scale in the car, and the smell of marijuana. Is that right? Is that about right?
Yes. And the government has also pointed to the fact that the driver got out of the car, which is not illegal and should not be considered one of the factors. But those are definitely the factors. Now, I will jump ahead and address the scale because I think that's the most interesting of these questions. The scale was found underneath a different occupant of the car, and Mr. Brown-ALFORD was in the front seat passenger side. The person who is sitting on the scale was in the back seat on the driver's side, sitting on a scale. And so
right, but they're in the car together.
Yes.
The windows are rolled up, the doors are closed, and the car is full of smoke.
Yes.
And the officers smell marijuana and see a scale, right? So we're looking at this all together. And certainly, as this court has made clear, there's nothing illegal about possessing a scale. In fact, these days, when you're only allowed to possess small amounts of marijuana, maybe having a scale around is a good idea, right? It helps you comply with the law.
Yes.
But it certainly is some evidence that the substance that they are smoking is marijuana, because you don't need to worry about, whether or not you're carrying around too much tobacco, right? you have a scale because you have marijuana, right? So
Well,
all of these factors together seem to provide ample support for reasonable articulable suspicion in this case.
Well, there are other reasons you could carry a scale around. I will start there. There are many
But
reasons.
it's not dispositive. Maybe you're going to go home and do some cooking, but it is one factor, one fact that can be taken in conjunction with the smell and the sight of smoke that might give the officers reasonable articulable suspicion that the people in the car are illegally consuming marijuana in public, right?
That the backseat passenger who was sitting on it might have been illegally consuming marijuana in public. I don't think that it gives reasonable suspicion at all for the front seat passenger on the complete opposite side of the car that he is consuming any marijuana. I will say in the government's brief, they did talk about possession of open container of alcohol cases and saying that if you're in the same car, then it's within your reach. And so it provides reasonable suspicion that way. But this is different because the prohibition here is not against the possession. It's about the ingestion of it in public. And so the fact that he is in a car with somebody else who has a scale and there's smoke in the car does not provide any evidence that Mr. Brown-ALFORD was ingesting anything. There isn't any such thing as constructive ingesting. You have to actually.
This sounds like a little, I mean, it just sounds like a slightly new argument to me. So let me press on it a little bit. What other evidence was there to support the conviction here? This was a stipulated trial, right?
Right.
So what other evidence was there other than what we're talking about that your client was in fact smoking marijuana? Was there a statement later that, yes, I was smoking marijuana?
I do not believe he was convicted of smoking marijuana. I believe he was convicted of a weapons charge.
Right. My mistake. Thank you.
Ms. Biederman, can I ask you a question? So one of the things that was litigated in the Superior Court was whether this location made it a crime to be smoking marijuana or consuming marijuana under DC Code Section 48-911.01. It's not clear to me that you've advanced your same arguments before this court. Is that something? Okay, so you're not contesting that this was a public space within the meaning of that statute?
Correct.
Okay.
So it seems like this case is becoming sort of slimmer and slimmer, right? That we're not contesting that this was public space. It sounds like now at oral argument, you're conceding that the seizure was when the trial court said it was. And I was reading your brief to challenge that ruling by the court.
Well, I think
on pages, I think it's 15 through 19 or something, but it sounds like you're saying, no, we'll concede that the seizure happened when the officers knocked on the door.
Well, I think that when they surrounded, I'll be a little more clear. When they surrounded the car in such a way that he could not leave, that's when the seizure occurred. And then within a second or two, he did knock on the door and order them out of the car. But it's when they surrounded the car.
What does that get you? I mean, because at that point, they can still smell the smoke and see the smoke in the car.
Correct. I don't think
maybe they can't see the scale at that point, but they can smell the smoke and see a car. I think the testimony is filled with smoke.
But I don't think that gets you probable cause or reasonable suspicion because
is that based on your statutory argument?
Yes, the statute specifically says that the smell of marijuana by itself or in conjunction with other factors that are enumerated in the statute or whether they're not enumerated is a question, cannot be reasonable suspicion. And the fact that there is smoke is not something that is illegal in order to get criminal.
Well, can I interrupt you right there? It says that you can't consider smoke to constitute reasonable articulable suspicion.
And the smell of marijuana.
You can't, the smell to constitute. Constitute is the verb.
Yes.
And it says you can't consider the odor to constitute reasonable articulable suspicion. You can't consider the odor in conjunction with possession of a small amount, right, that is specified in the statute, and I won't go through the specific amounts, or the odor in conjunction with possession of money, right?
Right.
But it doesn't say that you can't consider smell, full stop, right? It says smell can't constitute reasonable. So it seems to me that you're trying to rewrite the statute, and that your argument is that we can't consider smell. But that's not what the statute says.
No.
The statute says that the smell itself won't constitute, police can't walk down the street and think that somebody that they have passed smells like pot and stop that person just because that person's clothing smells like marijuana. That's not going to do it, right? But if you walk up to a car that is filled with smoke, suggesting that smoking is taking place in real time, and you smell burnt marijuana, that doesn't seem to be impermissible under the statute at all, right?
So in order to constitute reasonable articulable suspicion, it has to be not just other behavior, it has to be other behavior that suggests illegal behavior, right? It has to be evidence that there is criminal behavior is afoot. That's what the reasonable articulable suspicion case law says, that criminal.
But are you saying that each factor has to speak to criminal behavior on its own terms?
Well,
it seems to be contrary to our repeated statements that we look at the totality of the circumstances. And if you have smoke and you have smell and you look at them together and you say, wow, smells like something's burning, right? And I see smoke to indicate that something's burning and it smells like marijuana. That seems like the public consumption of marijuana. You're saying I can't follow that train of logic?
No, I do agree that we have to look at the totality of the circumstances, but there has to be something that indicates that there's criminal behavior and ordinary.
Well, it's a crime to smoke marijuana in public.
Yes.
So if I see something burning and I see smoke coming from it and it smells like marijuana, that seems like a basis to say I have reasonable articulable suspicion to think that criminal activity, i.e. smoking marijuana in public, is afoot. No?
No, I don't believe it does, because smoke can come from cigarettes. Smoke can come from so much.
It can come from cigarettes, but when it comes from cigarettes, it smells like tobacco, right? Or cloves or something else not like marijuana. But when it smells like marijuana, then you kind of think that the smoke is burning marijuana.
There is smoke in the car and there is a smell of marijuana, and but the smoke in the car is not indicative of anything that is illegal, because it could come from so many things, and it could be tobacco in the car as well.
Well, let me tweak the reasonable articulable. Let's say you're right, and you can't take into account the smell of marijuana. And you see people smoking in the car, and you see clouds of smoke. And what you don't smell is tobacco. I know what cigars smell like. I know what cigarettes smell like. And let me tell you what I smelled, it wasn't tobacco. So we take tobacco off the table. Is that reasonable articulable suspicion?
No, it's not. There has
It doesn't rely on the smell of marijuana. It relies on the elimination of the only other smell that is reasonable to think that smoke might be.
No, I don't think it does. I think that there has to be some indication from the factors that there's some criminal activity afoot. And even though you look at the totality of the factors, you still have to look at the individual ones as well in order to, the decision is made on the totality of.
Right, so tell me what they're doing that might be legal. If they're smoking in a car.
Yes.
And it's definitely not tobacco.
You don't know. I don't know. That's definitely not tobacco. I really don't.
I'm positing that an officer says, the hypothetical is, I see smoke in the car and the smell is not that of tobacco.
Yeah, but the smell of marijuana might be overwhelming it. Just because he doesn't smell it doesn't necessarily mean that's not what they're doing.
Ms. Biederman, let me ask something from a different perspective. By the time the seizure occurred, the officers also had seen baggies inside the car. So you combine that with the presence of a scale that's being sat on, which suggests an intention of hiding it from the officers who are looking in with their flashlights, and the obvious presence or apparent presence of marijuana. Why didn't all of this add up to reasonable articulable suspicion of possession with intent to distribute, which also would have justified a seizure? Because
the paraphernalia, which was baggies, was not found until after Mr. Brown-Alford was seized. If it had been seen before he was seized, that would be a different question.
I thought that it was seen.
No, it was after the police knocked on the windows, which is the latest possible he could have been seized, although we think he was seized when they surrounded the car and he could not get out. And just before they
I thought you acknowledged a moment ago that the seizure, you were okay with the trial judges finding that the seizure occurred when they knocked on the window.
I corrected that and said when they surrounded the car in such a way he could not get out, that's the seizure.
But if we were to agree with the trial judge as to when the seizure occurred,
the paraphernalia was found later. The paraphernalia was found after that.
Even after that.
Yes. So if the paraphernalia had been found earlier, then that could have been added to the totality of the circumstances. But since it was found later, it cannot be.
And the presence of marijuana and a scale, even without the baggies, that's not enough for reasonable articulable suspicion for PWID?
Not for Mr. Brown-Alford, possibly for the backseat passenger. But like I said, he was in the front seat. He was in the passenger side. The other person under whom it was found underneath somebody who was in the back of the car, all the way on the other side, as far as possible away from Mr. Brown-Alford. And there's absolutely no indication that Mr. Brown-Alford was even aware of the scale.
All right. Thank you, Ms. Biederman.
Thank you.
We'll hear from Ms. Kalu now, and we'll give you a couple minutes in rebuttal after she's done.
Thank you.
Good morning, Your Honor. May it please the court, Chim Namso Kalu on behalf of Appalachia, the United States. Your Honors, in this case, the government is asking that the court affirm the trial court's denial of Mr. Brown-Alford's motion to suppress. And we made two arguments in our brief on that point. And the first is that we believe that the trial court correctly construed DC Code 48-921.02a to permit officers to use the odor of marijuana in conjunction with other factors not enumerated in the statute to form the basis of reasonable articulable suspicion. And we—
How far, sorry to interrupt you, but how far does that line of analysis go, right? I mean, can an officer say, well, the person smelled like pot, but it's not just that, they also had dreads. And so, you know, the fact that they had this hairstyle in conjunction with the smell, that gave me reasonable articulable suspicion to stop them.
I think, Your Honor, the court the police would need to look to objectively reasonable factors to support any reasonable articulable suspicion. And so in that case, we looked at sort of traditional indicia of a particular offense, which here would be like what the police saw and testified to, the presence of smoke, perhaps the presence of paraphernalia, a statement that somebody was smoking marijuana, which the trial court inferred based on a statement that one of the officers made in response to something someone in the car said. You know, you're just smoking, you said. I don't think that, I wouldn't say that we're arguing that somebody's hairstyle, for example, would be something that police could look to in addition to the smell of marijuana.
Yeah, I mean, you're not arguing it now, but it might come up in the future because anytime there's a smell of marijuana, there's got to be some other factor that officers can articulate as contributing to reasonable articulable suspicion. It might be, so what about the smell of marijuana plus a high crime area? Do you think that could be reasonable articulable suspicion? And if so, what about the smell of marijuana plus somebody is wearing a shirt that has, a marijuana leaf on? Maybe that's it. And I guess what I'm getting at is if you can piggyback any little additional factor on top of the smell of marijuana, and that can get you reasonable articulable suspicion, that's always going to be the case. And the statute doesn't mean anything.
I would respectfully disagree, Your Honor. I think that the law still requires that the police articulate objectively reasonable factors that are somehow tied to whichever offense for which they're articulating that suspicion. And so
I just gave a couple. A shirt with a marijuana leaf or a high crime area.
And the court has said previously and repeatedly that we have to look at the totality of the circumstances. And so while there might be additional factors such as perhaps a t-shirt, if the totality of the circumstances don't suggest that t-shirt plus the odor rise to the level of reasonable articulable suspicion, then the court would be free to conclude that the police had not met their burden in that case. But again, I don't think the court needs to decide that here, because what we have in this case is not only the smell of marijuana, but an objective factor, which is the presence of the smoke that was in the car, as well as, again, what the trial court inferred based on an officer's statement to someone in the car that they were just smoking. And the offense for which they've had reasonable articulable suspicion here is the public consumption of marijuana, and the presence of smoke suggesting that somebody's actively smoking or had just been smoking, I would argue is, in this case, it's an objective factor that points directly to the offense at issue.
The government has a footnote calling into question sort of the validity of this statute, or whether or not it's really binding on this court. Is that a position? I couldn't tell if that's an argument that you're making, a suggestion for a future case. Could you just clarify what your view is on whether or not this statute, in fact, binds the court in a reasonable articulable suspicion analysis?
Certainly, Your Honor, and we wouldn't argue, and we're not intending to argue that the statute is somehow invalid, but rather that the violation of the statute does not lead to a constitutional remedy. And again, we don't think that the court needs to reach that question here, because we think that the police did comply with the statute based on what they saw and the fact that there were, again, objectively reasonable factors in addition to the odor of marijuana, factors that were not also enumerated in the statute.
Well, can you just articulate for me then with the argument that you are making? So I want to understand it better. So what we have is a statute that says you can't factor this into, or that's the wrong way to phrase it. It cannot individually or in connection with other factors that are enumerated combined to equal reasonable articulable suspicion. And if there's no reasonable articulable suspicion, usually we would say the seizure is illegal, suppression is warranted. As I heard you said, well, that's a statutory violation, so suppression wouldn't be warranted, but the statutory command seems to be one that intersects with the constitutional command. So why do you say that suppression wouldn't be warranted if, in fact, let's just take the easy example. All they do is smell marijuana and arrest somebody. Could we say no reasonable articulable suspicion under the statute? That was a statutory violation, but no suppression, because once we consider it in some separate world, it would be reasonable articulable suspicion, so suppression isn't warranted. Could you just explain it to me?
I think, Your Honor, we're talking in a broader sense, that the statute does not change the meaning of the Constitution, but we are not arguing that this court would not be bound, or that the police would not be bound by the statute. And I'm sorry if I'm being unclear.
That's okay. It's okay. It's a footnote. It's unfair of me to keep going on about it. I was just curious what the argument was. I wasn't sure I understood it.
I mean, I guess I'm still a little bit confused, and then we'll wrap this up and move on. You know, you say it doesn't change the constitutional argument, but it seems like what the council was trying to say is, look, we've decriminalized possession of small amounts of marijuana, which means that people are going to have marijuana, people are going to be using marijuana lawfully in certain places, and they might end up smelling like marijuana. You cannot use that against them in determining whether there's reasonable articulable suspicion to stop them on the street, right? It seems quite in line with the constitutional analysis, just kind of putting a pin in it. So what exactly is the government's problem with the statute?
The government does not have a problem with the statute, Your Honor. Again, we're just pointing to, from a broad sense, you know, even looking outside of this jurisdiction, that statute certainly doesn't change the statute doesn't change the constitutionality of a stop writ large, not necessarily in the District of Columbia. But in any event, we don't think the court needs to reach that here, because there was more than the mere odor of marijuana in this case.
Can I follow that line of the other things that we wouldn't need to reach in this case? I think Judge Kravitz asked about reasonable articulable suspicion for quid. And I'm wondering, correct me if I'm wrong, but I don't believe the government ever argued that there was reasonable articulable suspicion for a different crime other than public consumption of marijuana. Is that correct?
We did not argue that in the trial court.
And so we don't need to, and you haven't argued that in your briefs here. So there's no reason for us to delve into whether or not there's reasonable articulable suspicion for to stop for quid, right?
I think that's correct, Your Honor. And just to answer a factual question that came up with respect to the baggies when those were found, I do agree with Ms. Biederman. The baggies were found after the point at which the trial court found that there was a stop. I would guess that the reason that the trial court referred to the paraphernalia is because those baggies were in plain view, and they saw them, the police saw them before Mr. Brown-ALFORD and the other passenger had stepped out of the vehicle. But I don't think, because we are looking at public consumption of marijuana, I don't think that the baggies are necessary for the police to have believed that there was a reasonable articulable suspicion that offense might be taking place.
And last question on things that we don't need to get to. You know, the government did make an argument that the seizure happened later, but if we agree with the trial court, or if we reject the argument that the trial court's temporal designation of the seizure was incorrect and that the seizure happened at an earlier point in time, we don't need to get to the government's argument that it happened at a later point in time. Is that correct?
Yes, that's correct, Your Honor. I think in light of Torres versus Madrid, I shouldn't say I think, in light of Torres versus Madrid, the government is not pursuing the argument that's set forth in, I believe it's part 2B of our brief about the later time of the seizure. But to your question, Judge Easterly, about when the seizure occurred, we do believe the trial court was correct that the seizure did not occur until the police knocked on the window and asked Mr. Brown-ALFORD and the passenger to step out of the vehicle. But even if the court
Can I pause you right there? So Ms. Biederman argues, well, they surrounded the car. And I guess I wonder what the government's argument in response is to that.
There'd be two arguments to that. First, it's not clear to the government based on the body-worn camera or the testimony that was presented at the suppression hearing that the car was surrounded. There were two officers that approached the car initially, and the testimony was that the smoke was visible in the car at that point, and that the police could smell marijuana immediately upon coming up to the car. And so to that point, Your Honor, even if this court were to find that the seizure took place earlier, that is right as soon as the police came up to the vehicle, those two factors would still remain. The smell of marijuana, which again, the testimony that it was, the odor was emanating from the car, and that was apparent immediately upon approaching the vehicle, and the clouds of smoke were certainly visible in the car as well. And so even if this court were to find that the seizure took place by the police merely walking up to the car, on the officers that walked up on the passenger side and the driver's side of the car, I think the court could still be confident that there was at that point reasonable articulable suspicion for public consumption of marijuana. And so the seizure would have.
Can I just ask about, I just want to make sure I understand the record on that. I think, and just correct me if I'm wrong, I think Officer Madera testifies that he can smell it upon approaching the car. My understanding from the body-worn camera footage, but I could be wrong, is Officer Madera is the one who's at the driver's side of the door. And it looks like the other officer is there with his flashlight already kind of probing in the car before Officer Madera gets there. Do we know if that other, does that sound right to you that there's another officer before Officer Madera who's shining his flashlight in the car? He's the one who said, my man's sitting on a scale. And B, do we know if that officer smelled marijuana upon approaching, or if it was only the second officer who testified to that?
I think as far as that exact phrasing, immediately upon approaching the car, I think that it was only Officer Madera who said that. Officer, I believe it was Kellerman that you're referring to, Judge Deal. He, based on the body-worn camera, I don't remember if it was him or Officer Kelly, they did at some point in their discussions with other people around the car make reference to being able to smell the marijuana, and that was prior to the doors being opened, prior to Mr. Brown-ALFORD or the passenger stepping outside of the car. And so I think the court could reasonably infer from that all of the officers were able to smell the marijuana when they got close to the vehicle. And I see that my time is concluding, and so unless there are further questions from the court, we would again ask that this court affirm the trial court's denial of Mr. Brown-ALFORD's motion to suppress.
Thank you, Ms. Kalu.
Thank you.
Ms. Biederman, we'll give you just a couple minutes to wrap up.
Certainly, just briefly. There is nothing in the record to do what the government just argued, that they could reasonably conclude that everybody could smell it. There's the only indication that there was any smell of the marijuana was from Officer Madera. I also wanted to just clarify the.
Isn't it enough that one officer smelled it before the seizure occurred?
Well, it's not enough if the statute says that's not enough, which is what our argument is. But I'm just responding to.
What if your argument? What if we disagree with your argument? I mean, it doesn't matter that four officers as opposed to one smelled it, does it?
It was more just a response to what the government just said, that you could reasonably assume that everybody could smell it. I was just saying there's no indication of that whatsoever in the record.
Can I ask you one question? I should have asked this earlier, but you, at the very opening of your argument this morning, you said there were two questions that we had to answer. One was when the seizure occurred, and the second one was there reasonable suspicion for the seizure or the stop, and was there probable cause for the seizure? Can you tell me what you meant by the last part of that?
Well, just I was just putting that in. I actually think it's reasonable suspicion, but I wanted to add the probable cause in case the court found that it was necessary to find probable cause, which I think it's pretty clear that there is no probable cause. So as long when they ordered the people out of the car and they grabbed the handle and tried to open it and get into the car, and even when they surrounded the car, they need to have reasonable suspicion to do any of that. But by the time that they put the hands on Mr. Brown-ALFORD, they certainly needed the probable cause, which they did not have. But I just wanted to quickly just run over, since there were a couple questions about the timing. The police started to approach the car, and within 30 seconds, they had surrounded the car with 5 officers, not 2, 5 officers and 2 cruisers. And that all took place from the start of the approach until the surrounding was only 30 seconds. Then within another less than 30 seconds, the police mentioned the scale, knock on the window, order the people out of the car. And within 12 seconds, they're trying to get into the car by trying to open the doors themselves.
I have up on my screen right next to me the body worn camera footage that I can helpfully toggle through. And at the point where Officer Kelly is knocking on the window, there are 2 officers by the car. I mean, they're police cruisers down the, in the parking lot, but it looks like the car can pull straight out. And there's, 1 officer on the driver's side who, as Judge Deal mentioned, walks up to the car after the other officer on the right side of the car is already there. I mean, surrounded sounds ominous. It just looks like 2 officers walk up to a car, and the driver's already exited the car.
Yeah, the driver's already exited the car, so that the officer on the side next to the door where Mr. Brown-ALFORD is enough to keep him in the car by itself, because the driver's already in the car and they can't.
Why is that? I mean, the driver felt like he could get out of the car
before the police surrounded the car. He got out of the car before the police got to the car. He got out immediately when the police were entering the parking lot. He got out of the car, took the keys, and left.
Yeah. And Mr. Brown-ALFORD is sitting where in the car?
He's sitting in the front seat passenger seat.
Right. And there's no one blocking that door.
There was an officer that was at that door, and that he could not get out.
The officer is at the back of the car. I mean, at least according to the body worn camera footage, it looks like he's looking at the backseat passenger and talking about my man sitting on the scale. Anyway, it's just, I'm not sure that your description of surrounding the car really matches up with the footage, which, we have these days. We can see exactly what the police officers saw.
Right. Well, I think it does match that, but even beyond that, the fact that they were demanding that passengers get out of the car and that they couldn't go anywhere else, and that they did try to get in and then grab them the second that they were able to get the doors open, that Mr. Brown-ALFORD opened the door, and he was immediately grabbed. That's all part of the totality of the circumstances, that he was not free to leave at that point. The government in their brief made a strange statement that he was free to go about his business because he did not get out of the car for 2.5 minutes after they came up. But that's not what free to go about your business is. Free to go about your business includes leaving the area. And I think it was fairly clear from the video that he could not leave the areas from the time that the police approached the car. So for all those reasons, we would ask that the court would reverse the trial court's decision.
Thank you, Ms. Biederman. Thanks again, Ms. Kalu. We appreciate both of your arguments, and the case will be submitted.
Thank you.
You all may leave the courtroom, and we're going to call the next case. The next case on our calendar this morning is 20 CV 293, HOODBHOY versus the District of Columbia. Make sure that all counsel are present. I believe everyone is here. Counsel for appellant, if you would introduce yourself for the record, and let us know how much time you would like for rebuttal.
Yes, good morning, Judge Easterly. My name is Patrick Regan. I represent Ms. HOODBHOY in this case, and I would like to reserve 4 minutes if I can, please.
Please proceed.
Thank you. Good morning, Your Honors. May it please the court. The key question presented by this appeal is whether the public duty doctrine applies to a case such as this one, where the District of Columbia failed to exercise reasonable care as to the supervision of a person that the district knew to be a violent and unstable, and that the district knew was likely to cause bodily harm to others if not carefully supervised. The answer to that question is no. Whatever the merits of the public duty doctrine articulated by this court in its various decisions, we can agree that it has parameters. It may not be a perfect square with right angles.
I don't know. Can we agree on that?
I think in the abstract, Your Honor, I would like to say, yes, we can. I do admit that in the words of one jurist, it's somewhat incoherent jurisprudence, but it does have a shape, okay? Whatever the shape of the public duty doctrine, this case is outside of all prior decisions of this court. And so a word about semantics here, just so that I'm not misstating anything. Clark discusses exception, but in light of the codification by the City Council, we are really talking about whether this case is outside the scope of the public duty doctrine as codified. There's no suggestion in the legislative history or in the law itself that the legislature intended to broaden the scope of the public duty doctrine beyond how it had been interpreted through Allen in September of 2014. Neither before the decision in Allen nor after has this court ever applied the public duty doctrine to a case such as this one, where the district failed to exercise reasonable care as to its custody or supervision of a person that the district knew to be violent and that the district knew was likely to cause bodily harm to others if not carefully controlled and supervised.
That might be true, counsel, but the principle that underlies our public duty doctrine cases is that if the duty is one, the duty that is identified is one that is owed to the general public, as opposed to a special relationship with the individual harmed, with the individual who is harmed ultimately, then the public duty doctrine tends to come into play to say that there was no specific duty to that individual to prevent the harm. And in this case, I think the arguments you're making would have applied to anybody in the district who Hillman Jordan, it didn't need to be somebody in his building. It could have been somebody across town. If he had attacked somebody there, I think they would have the same arguments that you have. And that strikes me as incompatible with the public duty doctrine because it's not targeted to a specific duty to an individual, but it sounds like one that you're saying was owed to the public at large.
Your Honor, what we're saying is that if this case isn't governed by the public duty doctrine, then it's governed by common law tort principles. And foreseeability governs the issue of.
Yeah, well, let's start with whether or not it's governed by the public duty doctrine. And my reaction to that is, well, show me a special duty to the individual that was created and not one to the public at large. Otherwise, it's going to be controlled by the public duty doctrine. Am I wrong in thinking about the legal principle that way? And if so, can you point me to a case in our jurisprudence in the DC Court of Appeals where we have strayed from that principle? And if I'm not wrong in thinking that's the principle, is there some way that you think you can wedge yourself within that principle, that there was a special duty to Mr. Budo to prevent Hillman Jordan's actions as contrasted with the general public at large?
Judge Deal, what I would say is this: there's a special duty here. The special duty is between the district and Mr. Jordan. That is the special duty. They have a special duty with him. And if what we're saying is that if this case if this case isn't controlled by the precedent of the prior judicial decisions, and it's outside the scope of the public duty doctrine, then we're not dealing with the question that you have presented, which is this a duty owed to the general public? We're talking about common law principles of tort law and foreseeability. And no matter how narrow the definition of foreseeable people is narrow, these people, this couple, they shared a common wall with the assailant. So no matter how narrow that foreseeability is, if we're not in the public duty doctrine, then the common law principles as articulated in—
Mr. Regan, I think Judge Deal's point is that unless you can explain to us why we're not within the public duty doctrine, that we are within the public duty doctrine. So what takes us outside the public duty doctrine?
Well, the answer, Judge Kravitz, is this, that in the Clark decision, this court specifically declined to hold that facts analogous to this case fall within the public duty doctrine. Now, they used the word, at that time, they used the word exception. And I'm arguing or suggesting that because it's been codified, that this case is not something, the facts of this case were not codified by the city council into the realm of the public duty doctrine at that time. I mean, we have Clark specifically—
Can I interrupt? And am I understanding, you're saying, look, what is a public duty? Public duty is a term of art. And this court has interpreted that term of art in a variety of cases in ways that is or isn't so coherent. But we haven't defined whether or not the duty to take care of someone who is clearly dangerous and provide them with adequate supervision is a public duty or not. And so because we haven't decided that, this doesn't fall within the term of art. I mean, it's a clever argument, but I'm not sure that it's gonna persuade here today.
Well, Judge Easterly, the corollary of that is that this court is then expanding, in this case, the scope of the public duty doctrine, okay? And so what we're saying is there's no intention, there's no intention by the city council. I mean, look, the handwriting was on the wall, okay? When the rehearing was granted, the handwriting was on the wall, that there were enough judges that were concerned about the incoherence, as we're calling it, to say, this doesn't make sense and we need to relook at it. And so what I'm saying to the court—
It wasn't just that, it was that the statute had been passed and an order had been issued asking the parties to brief what the statute meant, because a majority of judges weren't clear as to what the statute actually was trying to do. It's an unusual statute, to say the least, to say that they're going to ratify a body of case law. But put that to the side. If your argument that this term of art of public duty has never been applied to this case, if that doesn't persuade, then you do have to be in this special relationship exception, right? That somehow there's a special relationship. And I wonder, is there any argument that there's a special relationship? You just said, well, these people have a common wall with Mr. Jordan. Are the people that he could, one could anticipate him coming within daily contact with, have a special relationship with the district? I don't know. I mean, I don't know why Ms. Powell had a special relationship with the district just because she tried to get her license plates renewed. Somehow we thought that created a special relationship, but someone who is being treated by an EMT poorly and negligently and dies, they don't have a special relationship. So I'm not quite sure I understand what creates a special relationship and what doesn't, but maybe that would be something that you could focus on.
Okay, well, Judge, I think that does take us back to your very first question this morning, and that is, are there parameters on the public duty doctrine? And I would suggest that there are. All right, and so what you're now, and if there are parameters, then this case is clearly outside of all the prior precedent of the court. And if the parameters are to be construed as what the court had previously articulated, coherently or not so coherently, in prior decisions, then this case is outside of it. But if you're then, if the court is not persuaded that this case falls outside the scope of the public duty doctrine as previously articulated, then yes, then the neighbors, there's no matter how narrowly you define the special duty or the foreseeable harm, these people fall within it. These are people who are interacting with this dangerous person at least daily, sometimes multiple times on a daily basis. So while Judge Deal suggested that someone across the city who came in contact with him on one occasion may fall within my definition, I'm saying no matter what the definition is, if it applies, these people these are contiguous neighbors. They're living there. He was killed because of an act. Dr. Budo was killed because of an act associated with him living next door or directly above Mr. Jordan. So our alternative argument is to create an exception in this case where the district has a special relationship with someone they know to have dangerous propensities. But I think the easier analytical framework is, okay, we've had cases before, those were codified. There's been no indication that the legislature intended to broaden that scope. And so this case was specifically excluded by Clark, and it's never been addressed.
It was not specifically excluded. It was, we're not going to address whether or not that potential exception exists.
Judge Deal, I think that, yes, you and I are saying the same thing, I believe. It's not included. Under any circumstances, it's not included, whether they decline to do it, but it wasn't included in the rationale. I mean, it's...
They didn't decide whether to include it or exclude it.
Correct. They said whether an exception should be made. And that's why, the subsequent cases have used the word exception. We used it in our briefing. But I think the easier way to look at it is that there is some shape, maybe it's amoeba-like, there is some shape on the contours of it. And whatever the shape is, this case is outside that shape. This is a dangerous person. It's difficult, if not impossible, to articulate a single public policy reason why the district should have immunity in this case.
I mean, it's difficult for me to articulate a public policy reason why officers who receive a phone call to an active burglary and let the people who are there be abducted and raped for 14 hours because they can't be bothered to go inside. It's difficult for me to understand why they're not liable either, but we said that in an en banc opinion in Warren. And I don't understand why those officers had less of a special duty to the people who were calling to complain about an active attack than what we have here. I don't see why you would say no special duty there, as we've said, but a special duty here because it was foreseeable. There, it wasn't just foreseeable, it was happening. It was going on, and they blew it, and horrible things happened. And now it's foreseeable, but it's foreseeable to the general public, so far as I can tell. It is a generally dangerous human being that was let out and should have been revoked. Could have gone after anybody, and the two exceptions you posit would apply to the general public at large. And that's what I'm having a hard time with.
Judge, I am in complete agreement with you about the police officers. Now, the distinction I would make is that in that case, the district did not have specific knowledge of the danger associated with this individual. Now, I would readily concede, I think that's a distinction without a difference, except that in this case, they had that knowledge.
Without a difference? I mean, it seems like it makes all the difference, right? I mean, at the time in Warren, when the police were charged with, when the police were arguably negligent and didn't go in the house, they had incomplete and imperfect information. They had some report of harm, but then, it seemed like the house was empty. Granted, they should have checked a little bit more, but here we have someone with a track record of mental health problems, who has injured people twice, right? And then is let out, but on strict conditions that then the district, that were imposed precisely to ensure that he doesn't hurt another person. And then the district doesn't follow those strict conditions and doesn't monitor this person who is a known risk. And they know where he lives and they know what he's capable of. So that seems to be quite different than the situation.
Judge Easterly, I apologize. It was sloppy language on my part. I meant that with respect to Warren, it's a distinction without a difference. There should have been liability in Warren, okay? I was, when Judge Deal said it's difficult for him to conceive why the district wasn't held responsible, I agree with that. I wasn't pointing out that this case isn't dramatically different from the facts of Warren because of the knowledge. I was inartfully suggesting that in the Warren case, that wasn't a distinction that should have played out. But here's what I would say. Isn't it time to rein this in? I mean, has the time come to rein it in, or do we let it run amok? And at some point, good public policy has to take over. Fairness. What about fairness? Where is the fairness in granting immunity? Where's the deterrence in granting immunity? I don't see my clock. I guess that's my fault here, but.
Mr. Regan, isn't this an argument at this point to be made to the DC Council rather than to us, given that apparently that you agree that they've codified the earlier decisions of this court, which don't seem to favor your position?
Well, I don't agree with that last statement. I'm sorry, Judge Kravitz, I don't agree with that it doesn't seem to favor my position. Yeah, I think it's lousy legislation. As bad as some of the appellate decisions were, I think this is lousy legislation. I think this was an end run around this court. No, I take that away. There's no think there. There was an end run by my opposing counsel and an end run around the Court of Appeals. It's horrible codification, but that's the reason. That's exactly the reason to say enough. We're not going to expand it. We're going to say this is different. This case, whatever term we want to use, wasn't decided, it wasn't ruled on by Clark. This is outside the scope of the prior decisions, and we're not going to perpetuate this craziness. And so that's what I would say. And I know I'm out of time, and I apologize. So hope you won't hold it against me on my rebuttal.
We will not. We will give you a couple of minutes. We let you go over a little bit of time, and we'll certainly give Ms. Johnson a little bit of extra time to respond to your arguments. So let's hear from her now, and we'll hear from you again in rebuttal.
Thank you.
Johnson.
Good morning. May it please the court, Holly Johnson for the District of Columbia. I want to start with a special relationship because I want to make it clear who needs to be involved in the special relationship. The only special relationship that can exist to allow for the district to be held liable for the criminal acts of a third party is a relationship between the victim of the crime and the District of Columbia, not between the victim of the crime and the perpetrator, not between the District of Columbia and the perpetrator. The special relationship has to be between the district and the perpetrator. This is why all third-party crime cases, all of them that the court has decided, require a special relationship, because it is the special relationship that takes the plaintiff out of the realm of the general public and creates a duty to the individual. I wouldn't even say the special relationship is an exception. It is simply a way of determining whether the duty is to the public at large or to the individual. Now, Ms. Hoodbhoy.
So why couldn't we say, Ms. Johnson, that the people who are living in the same apartment building or condo building, I don't know what the structure was, as Mr. Jordan had a special relationship with the district by virtue of Mr. Jordan's release conditions, by virtue of the known danger that he had posed in the past and apparently still posed, given the fact that he was supposed to be under strict monitoring and supervision while out on release? Why couldn't we say that constitutes a special relationship, because this gets back to my sort of term of art, like all of this is, terms of art, right? Like, what is a special relationship, right? Why couldn't we say that amounted to a special relationship?
Well, I have two responses to that. And the first will be quick, which is that Ms. Hoodboy has never argued there's a special relationship. She didn't argue it in the trial court. She didn't argue it in this court. So it's completely forfeited. It's not even something that we briefed. Second of all, special relationship has two prongs. And the first prong is the foreseeability prong. The first prong requires direct and continuing contact between the victim of the crime and the district. That's what makes the person a reasonably foreseeable plaintiff. Now,
I know that that's how we've defined it before, but I'm saying why can't we expand the special relationship and say, sure, that's what we've said before, but we're going to add on to what the special relationship is.
Sure. So
I say that this class of people, it's completely foreseeable that they might be injured by someone like Mr. Jordan.
Okay, so I have a couple of responses to that. There's a lot here that I need to unpack. First is that first prong, the foreseeability, which is sort of where I think this court is going, or where you, Judge Easterly, are going with that, is only one prong of the special relationship. The second prong is absolutely required by this court's prior case law. In Warren, on page 10, it says it must be foreseeable and there must have been specific assurances giving rise to justifiable reliance by that victim. Nealon says the same thing.
I'm gonna stop you right there and say, but why couldn't we, right? In this situation, this scenario that we've never addressed before, where you have someone, it's not just, some nameless, faceless person that the district is not aware of who's committing a crime, raping people in their house, or who's, even someone who unexpectedly, escapes from prison, right? This is a person that the district is aware is dangerous, is aware has mental health problems, has decided, okay, we can let them out, but only on the condition that we monitor him in this way, and he has to be monitored in this way. In that situation, why can't we say the special relationship just arises under simple foreseeability, and the second part of the test doesn't matter, and for this scenario, this is how this is going to work? Why can't we do that?
Well, that would be inconsistent with, and I'm going to count it, 5 cases this court has decided.
It's not inconsistent because we've never looked at this scenario before.
I believe this court has looked at a scenario that is close enough that this would be in violation of its prior decisions. In Varner, this court found that it was irrelevant whether it was foreseeable that the perpetrator who was left at large, whether his presence on campus in the same dorm as the victim would put that victim in danger. It found it irrelevant in footnote 11. And in other cases, these two prongs are at the heart of the public duty doctrine. Anyone who had been hurt by Mr.
It's at the heart of the public duty doctrine as we have constructed it.
Yes.
To date.
Yes.
Which the council ratified it, whatever that means, as it had been constructed to date, but didn't say, I don't know what it means to ratify. Does it mean, set an amber and you can never do anything else? And which way does that cut? Because when you get a scenario where we've never addressed the scenario, what are we supposed to do, right? We're a common law court, so we apply principles and we modify principles based on different factual scenarios. So I have no idea what the council thought it was doing when it said it was going to ratify our prior precedent, but I don't see why we couldn't say, well, under these situations, we're going to apply the special relationship or the public duty doctrine itself a little bit differently. And if the council doesn't like it, the council can legislate an actual, real, serious statute that tells the public when they want district officials to be held accountable and when they don't want them to be accountable.
Well, we would argue that the court is just as bound by this statute as it is by any other, and that the most reasonable reading of ratification is that for the purposes of this panel, that it would treat prior decisions as precedential in the same way that a panel is always bound by precedent. The statute.
Exactly. We will be bound by precedent just the way that we always are. But precedent has its limits. And to say that the council said that we were bound by precedent in legislation, is there any indication in this legislation that the council understood what our decision said? I mean, the district has done an able job, a masterful job, I would say, in its brief to make the public duty doctrine sound like it makes sense. But there's no indication that that was before the council. It's no indication that the council understood the public duty doctrine to mean what the district has said in its brief to us in this case. And am I wrong? Am I missing some legislative history here?
Yeah,
I don't see anything.
I believe.
Indicates.
I'm sorry to interrupt you.
No. I'm talking in fits and starts, so I don't mean to interrupt you. But if there's any indication that the council understood the public duty doctrine to mean what the district has presented in its brief, I'd be very, very interested to see it.
I believe that the statute itself, which ratifies this court's decisions, it's agreeing with this court's decisions, is in itself, and I mean, to assume the council didn't know what those decisions were when it ratified them is really underestimating the weight of this legislative body. And I don't
know if this court's done that great a job of understanding our precedents. So they shouldn't take too much umbrage at it. That when the people who do the work can't nail it all down, that they might not know all the ins and outs. But can I just ask if I understand your position correctly? You think the legislation effectively was something like a super en banc decision. Everything we've said previously is the law, and we can't address it again en banc. It is set in stone, and we could not overturn it en banc. Otherwise, the law is open to ordinary common law development, and those precedents can be interpreted, reconciled, caveated in the way that precedents always are during common law development. Is that an accurate restatement of your position?
Yes. Yes, that is how the court should treat this. And I would like to address, I don't think the question is properly before the court, but it's been so much at the heart of this argument that I feel like it's important for me to discuss that this case is a classic example why liability in some circumstances should not drive government decisions regarding the public good. People with mental illness are entitled to the least restrictive treatment. And release of someone who is mentally ill and previously been violent is going to always be fraught with risk. And this is the same for bail decisions or compassionate release decisions. And if the district is held liable, if psychiatrists are held liable when they make these tricky decisions regarding whether someone is dangerous or whether someone should be released, then individual liability cases, these outlier situations may well drive the public or may well drive decisions regarding release. So the council—
Well, that seems speculative. I mean, individuals who are suffering from mental illness and who are released into the community are also entitled to adequate support from behavioral health, right? And from their doctors. And so, I mean, the district was there not just to monitor and supervise, but also to support Mr. Jordan. And
absolutely.
It seems like they failed miserably in that endeavor as well.
Well,
so
certainly.
It seems to me that the public interest there's a dual public interest in holding the district liable here, although the policy is not before us, right? But one could make strong arguments to say, we want to hold the district liable because we want them to do better, both for the general public, both for the hood boys of the world and for the Mr. Jordans of the world. This shouldn't have happened.
Mr. Jordan did have a special relationship with the district. The case is not brought by Mr. Jordan. This case is brought by Ms. Hoodboy. Now, her exception, this proposed exception that she's asking for, simply makes no sense within the contours of the public duty doctrine. What she is challenging is not whether she had a close enough relationship with the district to be considered different from the general public. She is conceding that the duty is to the public. The exception that she is seeking is based on the type of breach of duty.
And Ms. Johnson, I see where you're going, and I just want to ask, if one of the conditions, or not a condition of release, but part of the release plan was DBH was to notify all neighbors that Mr. Hoodboy would be living on that block. Do you think that would be enough to create a special relationship for purposes of getting around the public duty doctrine?
I do not. And I would say that that's because of the Varner case, where the police had actually gone to Gallaudet University after the first murder and had told them that the university students that they were going to be doing extra patrols and keeping an eye on them and keeping them safe. And that was found to be insufficient because there was a lack of justifiable reliance. So you have to have both direct and continuing contacts between the victim and the district, and you had to have justifiable reliance. And neither of those prongs is met here. And yes, of course, every case is going to have somewhat different facts, but new facts does not mean that it does not fall within the principles of the prior cases. So we know from the Cunningham case that the knowledge that a perpetrator was dangerous is not sufficient to step outside of the public duty doctrine. In that case, the psychiatrist knew the perpetrator was dangerous, but told the patrol board he presented the parole board that he presented no danger to community. Right? We know that not telling the court about someone's dangerousness cannot escape the public duty doctrine, first because of Cunningham, but also because of Akins, where the pretrial services agency did not tell the court of the perp's criminal history before a hearing regarding his threat to the community. We know that mandatory supervision cannot get outside the public duty doctrine because of Clark, where the Department of Corrections was required by regulation not only to monitor the perpetrator, but to confine him at night to verify his job.
I guess my pushback on your reaction to that example is here, in the hypothetical, there would be a court order saying that they have to notify the other neighbors. And it sounds very similar to Turner to me, where there's a statute that protects, if I'm getting the case name right, a statute that is passed for the express purpose of protecting children from abuse. And we said that can get you around the public duty doctrine because that's made to protect those children in specifically. Whereas, there's nothing like that in Varner. But a court order that said you have to notify the neighbors would seem to be very much like Turner in creating a special duty to the people who were expected to benefit from that if the police drop the ball on it. But you don't think so?
Well, that's actually an interesting question. I've never considered it. Certainly, if there was a statute, I think there would be an argue that there was a statutory special relationship. I imagine, but you can't hold me to it because I've never looked into it, but I imagine that a court order would operate similar to a statute in that context.
We have the release order here, by the way. I know it's referenced in the complaint a lot. I don't know if I've seen it though. Is it somewhere that we have accessible?
I don't recall whether I put it in the supplemental appendix. I do know that I referenced it. I'm taking a quick look through the supplemental appendix.
It's okay. I will. Don't get caught up on that. I'll look harder.
But yes, and certainly the way to find it is in a footnote of my brief. Like I do certainly let you know where it is. Absolutely. So, and we also know that the courts in 5 or 6 cases, this court has said that foreseeability standing alone is not enough. So basically every proposed exception that Ms. Hoodboy has raised is foreclosed. Basically every theory of negligence that Ms. Hoodboy has raised is completely foreclosed. I do want to add, I know my time is running out. I hope.
Please take more time. And I have at least one more question for you. So finish your thought.
All right. I wanted to talk quickly about Clark and White because I think this is a red herring, and I just want to highlight this. In Ms. Hoodboy's reply brief, she notes that White and a case that it cites, Hicks, both involved St. Elizabeth's Hospital. But I wanted to point out that at the time, the district was not the defendant. St. Elizabeth's was a federal agency, and the Federal Tort Claims Act at the time precluded the public duty doctrine. It actually says the United States has to be treated like a private person. So those cases are not about the public duty doctrine. They're simply about what the liability would be for a private institution hospitalizing someone who let them go.
So if I understand your argument, the district is saying, based on this conglomeration of cases, it's very clear under this court's precedent that Ms. Hoodboy's claim fails under the public duty doctrine. And if that is the case, do we need to interpret the statute that the council passed ratifying our precedent? And as the district is aware, in the Allen case, we did issue an order asking for supplemental briefing specifically on what the statute means. And I'm wondering, do we need to emerge from this case with a decision explaining what we think the statute means? Or is this a case where we can duck that question because whatever the statute means, we don't need to go to super en banc precedent status. We can just do our normal precedential analysis.
Yes, to the latter part. This court does not need, because this is simply a panel of this court, it is as bound by prior panel decisions as it would be bound under the statute. There's no reason aside from
but
that.
if you start talking about the statute, then I think that we have to talk about what the statute means or doesn't.
Well,
I'm asking whether we have to talk about the statute in this
no,
case.
not at all. Not at all. The panel's, the statute really only comes into play if this court goes en banc.
All right. Well, thank you, Ms. Johnson. We appreciate your time, and we will hear from Mr. Regan now.
Thank you, Judge. Let me address one of the points that was raised there, and that is we are not and have never challenged the decision to release Mr. Jordan. What we have challenged is the district's willful and repeated violations of the conditions of release. We've talked a lot about foreseeability, and the question that I would pose that I think answers the issue of foreseeability is when the Superior Court judge entered that order with 19 specific conditions pertaining to Mr. Jordan's release, who were the foreseeable people that he was attempting to protect? It wasn't Mr. Jordan, it wasn't DC employees, it was people who would come in contact with Mr. Jordan, and he wanted to, or she wanted to make sure that there were proper safeguards and they were ignored. So when we talk about foreseeability, who were the foreseeable people that were to be governed by the order of the court? And twice Ms. Johnson referenced Varner. I won't devote a long time to this, but I will say this. In that case, the district had no prior custody or supervision of the perpetrator, and they were unaware of his propensity to commit violent crimes. Completely different facts of this case, completely different facts. So the court set specific conditions for Mr. Jordan's release. That was to protect the very people that are before the court today. And with that, unless there are other questions, I'll rest. Actually, I will, seeing that I have a couple minutes left, Judge Easterly, I do want to address one of the cases you cited in your dissent in Allen, and that is the Rosenbaum case. It was my honor to represent that family, and I will give a quick story that I think is very apropos of this case, and it ties directly into the district's argument, and that is the deterrence value. Mr. Rosenbaum was killed in January of 2006. The lawsuit against DC was filed in November of 2006. In January and February, Mayor Fenty met with me and my clients and said, I want to set up a task force to improve the services. In March of that year, we entered a dismissal order against the district. March of 2007, we entered a dismissal order against the district of the civil case with the absolute right by the Rosenbaum family to refile in 1 year if they were not satisfied, subjectively satisfied that the district had made changes in the provision of emergency services. Task force, as all of you will remember, task force was convened over the course of the summer, and recommendations were made that dramatically improved the provision of emergency services to every single citizen of the district. That would not have happened. I can tell you from personal experience that would not have happened without the threat of a civil lawsuit against the district. So to the extent that there is a public policy issue here of deterrence, which the city has argued in their brief that it's going to create unwieldy liability, that's not true. This is a perfect example. The Rosenbaum case is a perfect example of why there needs to be accountability in a civil case. Thank you.
Thank you, Mr. Regan. And thank you again, Ms. Johnson. We appreciate both of your arguments, and the case will be submitted.